Chapter 2, Introduction continued. Number 12, State Governments. There is a government in each state organized in substantially the same manner as the national government, the basis or fundamental law of which is a constitution. Unlike the national government, however, a state government possesses all powers of sovereignty possessed by any nation, with the exception of those powers and rights heretofore mentioned as having been given up to the national government, and also with the exception of the restrictions which the people themselves have placed on their government in their constitution. 13. Differences between state and national constitutions. From the brief history of both state and national constitutions given above, it will be readily seen that they must differ widely in their scope. The national constitution is an enumeration of certain rights and powers. The state constitution is an enumeration of restrictions placed upon the state government by the people themselves. We here see two governments, distinct yet supplemental, in operation over the same territory, but not in any sense conflicting. Each has its functions, each has its own laws, and each is limited and controlled by its own constitution. 14. Statute Law. A bill, in order to become a national law, must receive a majority of the votes of each House of Congress and be signed by the President, or if vetoed by him, it can still become a law by a 2/3 majority vote of each House. A law passed in this manner is called a national statute. It is, of course, formally expressed and exact in its terms. The statutes in force are collected and published by the authority of the government. In a similar manner, laws are passed by the state legislature and signed by the governor. These are called state statutes. 15. Common Law. The common law originated in England so long ago that its exact origin is a matter of some doubt. The general opinion is that it arose from the customs of the times and long usages which finally came to have the full force and effect of the laws. The rule of giving to the makers of promissory notes these days, called days of grace, more than stated in the note itself, arose originally out of a custom which, gradually becoming more general and certain, finally was recognized by the courts as a right belonging to the maker. In other words, what was first a custom finally come to have the significance of a law. The common law is sometimes called the unwritten law because it is not formally expressed as the statute law, but is found in the reported decisions of courts. The common law was in force in England at the time of our separation from her. It had, of course, up to that time been in force in the colonies, and the people were familiar with it. Therefore, they naturally chose to adopt it and declare it to still be in full force and effect, so far as it was applicable to themselves. That the common law of England, so far as the same, is applicable and of a general nature, and all statutes or acts of the British Parliament made in aid of and to supply the defects of the common law prior to the 4th year of James I, and which are of a general nature and not local to that kingdom, shall be the rule of decision, and shall be considered as of full force until repealed by legislative authority. Act of the General Convention of Delegates of the Colony of Virginia, held at Williamsburg, Monday, May 6, 1776. Similar statutes have been passed by most, if not all, of the states, except Louisiana, which adopted the civil law instead. Order of Precedence, number 16. The national constitution consists of certain rights and powers relinquished by the states to the general government. It is therefore the supreme law of the land in regard to all matters contained in it. The national statutes being made in strict accordance with the Constitution must necessarily come next in order. The states, as we have seen, reserve to themselves supreme authority on many questions. They have also placed numerous restrictions upon their own government. In regard to these matters, the state constitutions of several states are supreme in authority. State statutes made in accordance with the state constitution are next in authority. And lastly stands the common law. When there is a conflict between statute of a state and a common law, the statute takes precedence until repealed, when the common law again comes into operation. The common law is in force whenever there is no statute upon a subject, and it thus supplies in what many cases would be a great deficiency in our statute law. No legislators could possibly foresee and provide for all the possible contingencies and difficulties that could and do arise in the business and relations of a complex civilization. 17. Commercial law is that branch of common law which more particularly pertains to contracts and ordinary affairs of business. It embraces more than the old law merchant, for that was mainly concerned with marine affairs and bills of exchange. Being a branch of common law, its source is the same as the common law, and is modified or annulled by statutes in the same manner. That completes Chapter 2 and the second part of the introduction.